Welcome back. This is Michigan Crime Time, and I am Jess, your hostess with the mostest. If this is your first time here, welcome. Thank you for watching. Today's case is in Judge Slay's courtroom out of Washtenaw County. I do not believe I have covered a case from Judge Slay yet. This case is a bit of a sleeper, as in it's been waiting for 7 years. The defendant does bring up some very good points that pertain to his case. I did do a deep dive into Michigan case law to see how that pertains to his particular motions, and if there's merit, I do have the links for the further reading in the description. I do have blurbs in the video itself, but if you're a law nerd like me and you like to learn, the links are down in the description for you to read the laws yourself. Also in the description are the links to join my circle of friends, the membership for my channel. As you may know, many videos of mine get demonetized due to the nature of my videos. So besides liking, sharing, and subscribing, a better way to support me is to join my circle of friends. Also in the description is the link to my merch store. It is currently live. I do have some special goodies for the doggos for our soft sit patrols that we go on. Also in the description, if you have any hot tips, leads, good cases that pertain to Michigan that you would like to see me cover, you can email me. It's jesscaris@gmail.com, or you can find me on Facebook, Michigan Crime Time, and you can message me directly there. Those links are also in the description. With that, all comments are my opinion. They are only my opinion, irregardless of any wording that I use. All persons are innocent until proven guilty in a court of law. I am not an attorney. I am not putting forth any legal advice nor making any legal conclusions. And my videos are not the official court record and not to be considered or used for court or official purposes.
Good afternoon, Your Honor. Michael Dobie for the people. Good afternoon, Your Honor. May it please the court. Leonard Ballard on behalf of Mr. Winburn, who appears from MDOC via Zoom.
All right, Mr. Winburn.
Your Honor, I don't know. I can't see the other person that he says he's my lawyer, but I don't know who he is. I haven't spoke to him or anything.
Okay.
Introduce yourself again.
I will, Your Honor. May it please the court. Leonard Ballard on behalf of Mr. Winburn. I have been to the prison. I have spoken with Mr. Winburn.
One time, Your Honor, for 45 minutes.
Okay, but you do know who he is, so.
Now I know who he is. Yes, I see.
Okay. Recently, there have been a lot of motions filed, and I'm just gonna go through to make sure that I have them all because they are coming over. Here's Mr. Winburn. You might be sending these without the assistance of counsel, and I do want to make sure that I have all of them, and then make sure that I have proper responses for them as well. And then we'll put on the record what we're going to address today. Okay.
Thank you, Your Honor.
Okay. So I have 9 pending motions in this case, and one was filed on 1/5. That's a motion to afford due process and order replacement counsel. Next on 2/3, motion for disqualification of the judge and referral to chief judge. 2/3 again, motion to dismiss based on 180-day rule and speedy trial and public trial violations. 2/3, motion to dismiss based on police and prosecution misconduct, lack of subject matter jurisdiction. 2/3, motion to replace counsel and lift all judicial edicts. 3/13, motion to vacate all previous orders by Judge O'Brien. 3/20, motion to withdraw as counsel. 3/21, motion to dismiss charges for lack of grand jury indictment. And 3/21, motion to dismiss charges for Trooper Tish, I think that's proper pronunciation, failed to preserve exculpatory evidence. And then another motion filed to motion as to withdraw counsel. What I don't believe I have responses to most of these, but what I'm inclined to do today is to look at the motion to withdraw counsel today, and if I'm going to hear that, and depending on the ruling of that, we'll put these other matters out for a time when counsel could be appointed to you, Mr. Winburn. So we'll start with the motion to withdraw counsel, Mr. Ballard.
Thank you, Your Honor. I was appointed counsel. I believe I'm 7 or 8 counsels that have been appointed in this case. This case came to my office, to the chief public defender in Jackson. I am with the public defender's office in Jackson County. Came to us from Genesee. It was requested that an attorney from our office take up this case. I did assume this case. I did get out to the prison as quickly as I could once being appointed. The prisons have made it quite difficult of recent. They have rescinded some of their pre-COVID or their during COVID allowances to call. I immediately went out there. We started receiving discovery from a number of sources, both from previous counsels, prosecutor's office. It totals a quite voluminous amount of discovery. I have been combing through this, at which time Mr. Winburn has continued to file various documents with the court. And of most recent, I received a letter from Mr. Winburn, an attorney grievance commission request for investigation, citing that my lack of communication with him has made me negligent. Your Honor, I will cite this. At that point had been 7 weeks, and the amount of discovery to pour through was, as I said, voluminous. There was no way to fully have an understanding of the case at that time. But upon receipt of this, I did file my motion to withdraw. I will say for the court, and in support of Mr. Winburn, when I met with him, his request is simply to represent himself. I do not know the full details of his previous self-representation, but I do believe a couple of things. I do think he should be afforded his constitutional right to represent himself, but I also believe that appointment of future counsel, other than simply stand by or support counsel, will result in further lawsuits or grievances. I think we're setting up counsel in a similar fashion. So again, outside of that, I do believe Mr. Winburn has the right to represent himself, and I would encourage that. However, at this point, my motion simply cites to withdraw as counsel in this case and to withdraw the Jackson Public Defender's Office in total.
Thank you, Your Honor. Again, Michael Dobie for the people. Mr. Ballard, I think, is correct in his assessment there that no counsel will be suitable for Mr. Winburn in his eyes. However, he also cannot represent himself. He has a jury trial was begun several years ago. He caused a mistrial after numerous warnings from the judge and instruction. He is incapable of conforming himself to the rules necessary to conduct a jury trial. Counsel representing him will be necessary. As to the relationship between Mr. Ballard and Mr. Winburn, I have nothing to add, except that yes, we have been through everyone in our county, and this is the third out-of-county public defender's office that have attempted to represent him in various levels of success.
Your Honor, may I respond?
What is it that you need to say, Mr. Winburn?
I just wanted to just draw the court's attention to in one of my motions, in the motion to dismiss, that you mentioned that you did receive and docketed. There is, I'd like to correct this, Mr. Dobie, that it's not that I don't have the right. I have a constitutional right of self-representation, and the previous order suspending that doesn't operate as a lifelong judicial edict that can constitutionally stand. I have a constitutional and common law right and statutory right of self-representation, and it's a misstatement of facts and of the historical record that I actually caused the mistrial. If the court looks at page 39 of my motion to dismiss, that's the motion that was filed February 22nd. I specifically, very detailed, outlined all the facts the prosecutor's office prompted a mistrial and claimed that falsely that I was incompetent to represent myself. And that's why I'm arguing at page 39 that the double jeopardy clause bars a retrial. And I'm asking the court to visit all my motions, allow me self-representation, look at the facts. I've been held, Your Honor, for 7 years as a pretrial detainee without a trial, right? And I've been treated worse than the Guantanamo Bay prisoners in GITMO, Your Honor. This is in the United States of America. This is not Cuba, and this is not communist China. But I've been treated worse, and they think the prosecutor. Yes,
Mr. Winburn?
yes, Your
So
Honor.
the motion on the floor right now is the motion to withdraw as counsel. And as I said previously, we're not going into any of the other motions.
Right.
It sounds like
Yes,
you
Your
have
Honor,
other
but he-
legal issues that you need to deal with
Yeah.
outside of what is on the docket for today. So what will be
Right,
addressed
the-
is the,
Okay, yeah,
Mr.
but the-
Winburn, I'm not,
Okay,
is the motion to withdraw counsel, which will be granted. I'll contact Ms. Hightower from our MD liaison to try to find another counsel to stand by for you. These motions will be adjourned out to May 15. Mr. Dobie, I would expect that I have responses to the motions.
thank you.
Your Honor, you're asking me to respond to the motions that he has filed himself? Okay.
Yes,
And in addition to that, Mr. Dobie, whenever the new counsel is appointed, because it looks like we've been through anywhere from 7 to 11 different attorneys at this point, I'd like you to take the opportunity to sit down and do kind of
Thanks.
an accounting of discovery. I understand it's customary that other counsel will give to the next. What I'm concerned about is we've had so many attorneys, maybe not everything has gotten to Mr. Ballard at this point.
They-
I'd like
Yes,
you
sir.
to have just an accounting, a double check to make sure that he has, he or she next will have everything that they need to.
Your Honor, thank you.
And obviously, Your Honor, I can't speak to us having everything. We will immediately comply with, once we're notified that there is new counsel, we will send it. I will cite for the court, we've had discussions with appellate attorneys in regards to this to see where they can go with this case. That was kind of the direction we were going, in hopes of getting an appellate attorney that can take up Mr. Winborn's issue to self-representation. Obviously, we are no longer pursuing that, given the order today.
Mr. Winburn, we will see you back on May 15th. Thank you, sir.
Thank you, Your Honor.
Your Honor, thank you, Your Honor.
Hey there, court fans. So, that was dorky. I need a different term. Anyways, what did you guys think of this case? This guy was found to be incompetent. I'm assuming that he had gone through mental health evaluations so he had a competency hearing. I need to do some further diving on this case itself. I'm going to try and see if I can find anything about his mistrial. Like I said, this is 7 years ago that it happened, so I may or may not be able to find anything. I will be following this case through as much as I am able to. Hopefully, they will soon be able to get him another public defender. And when that happens, then hopefully they can get the case rolling. He does certainly want to be pro se, which, I mean, they were able to make it work with Daryl Brooks, so they should be able to work with this guy. And as I said in the intro, if you do want to learn more or read more about the Michigan case law that pertains to double jeopardy, the links are down in the description, as is the link for the PDF of the trial Benchbook, which basically describes the entire process of a trial, every step, all the different rules that apply. So that link is also down in the description if you're a huge nerd bookworm like me. With that, I hope you enjoyed this video. Don't forget to like, share, and subscribe, and consider joining my memberships and joining my circle of friends. And I just have to say a big thank you for watching, Chima Gwitch, and have a wonderful day.